Welcome to Women Winning Divorce. I am your host, Heather Quick. I am an attorney, entrepreneur, author, and founder of Florida Women's Law Group, the only divorce firm for women by women. I love thinking big, thinking outside the box, creating creative solutions for women, and empowering women to win in all aspects of their life. Our approach at Florida Women's Law Group is to provide women with a strategy to not only achieve their objectives, but win at life. I believe that what may show up as adversity is simply an opportunity to change and improve your life. In each episode, I sit down with innovative professionals and leaders who are focused on how you can be your best self before, during, and after divorce. In these conversations, we are looking at how women can win at life. I have the unique opportunity to meet women when they are at a transition period of life. But that is only the beginning to becoming your best self and winning at life on your terms. With our guests, we enjoy the opportunity to explore ways all women can win and enhance their life, no matter where they are in their journey. Because divorce is just a point in life, not the end and not what defines you, rather a catalyst for your growth. Welcome to this week's episode of Women Winning Divorce. I'm Heather Quick, owner and attorney of Florida Women's Law Group. Today, our guest is Beth Luna, who is an attorney in the North Florida area and now currently serves as a magistrate for Clay County, Florida. And she's also the co-chair of the legislative committee of for the family law section of the Florida Bar. That's a lot, but you'll understand why I bring that up because it's so important. But welcome to the show, Beth.
Thank you for having me. I appreciate you including me about this topic.
Absolutely. Yeah. And now, how long, so our listeners know, because I know I threw out a lot of words, but let's start with magistrate and what you do in Clay County, Florida now, because I know they're going to want to know what that means.
So I am appointed as a magistrate and I am actually part-time down there. I'm not full-time, but it is what I'm doing primarily. I'm not, I don't have clients anymore. So that's the full-time gig, I guess, in some ways. And I basically do family cases, which would include divorces. It would include paternity, custody, time sharing, parental responsibility, all of those things. And I also do some mental health cases and some dependency cases. So that's part of what I'm doing down there. And for those that don't know, magistrates, we serve at the pleasure of the court. We basically hear cases, draft orders. We send it to a judge to sign, depending on where it's at. In family currently, once the judge gets it, they sign it. It's final. And you have a right to file a motion to vacate, which is like an appeal if you don't like the decision. So I guess we're kind of serving in some ways as helpers to make cases move faster.
Absolutely. And for our listeners, but many of our listeners, we have to explain that if you've been in a family law court proceeding, you very likely may have been in front of a magistrate, which really they serve as their hearing officer, but as a judge. It's all the same formalities. There will be a hearing, they hear evidence, they make decisions, and many times, most often, it helps our cases move faster to get in front of the magistrate, and the judges are always wanting attorneys and their clients to go in front of the magistrate again for things to get done a little bit more expeditiously.
And I think that we do a pretty good job of doing that, hopefully, of moving things faster.
Absolutely. And it definitely helps cases move along. And also, right, you hear a lot of cases when individuals come in front of you that are unrepresented. Is that correct?
We do a lot of self-represented individuals. So if you don't have an attorney, or in a lot of cases, there's one attorney and no attorney, we get a lot of those cases. So we are doing a lot of those, along with some with attorneys too, but it is a lot of self-represented.
Yes, because I know very often they'll go straight to you for unrepresented cases, again, for ease of scheduling and moving cases a little bit more.
That's right.
Yeah, so now, because, today, one of my favorite topics, and I know it still will be if this law changes, but love talking about alimony. I always do. And, but why I specifically reached out to Beth is because she, like I said, is on the co-chair of the legislative committee for the family law section of the Florida Bar. So Beth, tell us a little bit about what that means, and especially in regards to our topic today about alimony.
Well, so the family law section for a long time, they've always had a legislation committee. I don't know how far back it goes, but the goal of that legislation committee is to hopefully help make better laws for the families in Florida. And it's to move forward legislation sometimes that we create And sometimes it's things that other people have come to us with and we've assisted with. It is also sometimes, as you will know from years past with alimony, it may be objecting to bills that we don't think are necessarily right for Florida's families. Um, we have a pretty long history with the alimony bill.
A very long history. Yeah.
I don't know how many years we've been on this alimony fight. It's a little different in perspective this year than it's been in years past. In a lot of the years past, in fact, almost all of them, we have been really against alimony reform because we didn't feel that the bill was necessarily good for Florida's families. And, last year there was a retroactivity issue in it. There was also equal time sharing attached to it. So that was two things that kind of made us not like the bill last year. What people probably don't know is that several years ago, there was a group put together called the Alimony Rapid Response Team. And I served on that. And we sat down over a lot of meetings and started looking at the alimony statute and seeing if there was language that maybe we could draft that we could approve. And that process has been going on for years. We've sat on products. We've not done anything with them. This past year, what happened is that recruiters came to us and said, please help me with this bill to make it so it's not retroactive. I think the bill that you've got this year, it's had a lot of hands on it. When I say that, there's been a lot of lawyers within the family law section that have touched it. A lot of lawyers within the American Matrimonial Lawyers Association that have had hands on it. The reformers obviously contributed somewhat to this because the language started from last year's bill. So last year, they attempted to negotiate a bill between us and the reformers, and they couldn't get an agreement between us. This bill does reflect some of the agreements from last year. It also reflects, I think, some language that we took and tried to make better. So hopefully it is fair to both payors and payees. And that's the goal, right? It should be fair to everybody. So the family law section supported this bill this year. And that's probably the history on it as to where we are today. I know that when you look at this bill, there are some groups that I don't know that anybody loves it, right? Like it's a negotiated bill. There are some things that probably everybody would like to change. The reformers, I think, are maybe okay with it. The First Wives Club doesn't really like it because, they've got some concerns about it. And we understand those. Like, it's got to be scary when you're receiving alimony and you're looking at a big change in the way that this does. So our goal was to try to make it so it wasn't retroactive and that it was fair to everybody.
Well, and that's a great intro because alimony, man, it is always a hot topic. It has been for years because there's a lot of emotion tied to it.
Yes.
There is just a lot of emotion. I think anytime we talk about anything and money, and hey, we have a lot of emotions about money and a lot of emotions about alimony, it just heightens the level with which the discussions tend to go. I certainly was involved many years ago during one of those, as we discussed, it's been going on for a long time, and it got really heated, and I just expressed an opinion on the issue, and it was ugly. I had to take down a lot of social media because I got targeted as just very negative personally for things, just expressing an opinion on that bill at the time, which is, I don't know, 5 or 6 years ago maybe. But regardless, we're going to talk about alimony today. And I think let's start with alimony as we know it now, because I think that's a good place to start without taking a week to talk about it. We're going to try to hit the highlights for our listeners. But Beth, let's talk about what alimony is now in the state of Florida. Like how would you define that?
Well, I think the big thing probably that everybody talks about with this bill and what alimony is now is there's permanent alimony in the statute now. What I like to say about permanent alimony, and I've said this testifying to the legislature, permanent was probably the wrong word to use, right? Because there really is no such thing as permanent alimony. Alimony's always been modifiable with the exception that if you have an agreement, because you're not going to get it from a judge making that decision, if you have an agreement that says it's unmodifiable. And to me, those type of agreements were kind of few and far between because payors really don't want to agree to them. So it's hard to get those. So permanent was never permanent. It was typically, you could modify it if there was a substantial change of circumstances. You could modify it if there was retirement. There was case law that made it so. There was things in there about a supportive relationship that would allow you to maybe modify it. So it's kind of been a little bit of a misnomer that permanent was permanent. So that's kind of, I think, when I look at where we're at today with the bill, that's the big thing. Like, right? Permanency, that word, and that type of alimony.
Well, and it does, and it's and those are usually the permanent alimony cases, with, like you said, or air quotes around permanent for those who are
Yeah.
listening, but still, those are the cases that we have gone to trial most often
Yes.
over, because it's difficult for individuals to come to an agreement on that. But as the law stands, once you really meet some certain requirements, many of the judges, they're going to order that. They don't have a lot of options. And typically for our listeners, that's going to be a long-term marriage. And even if you think 5 years is a long-term marriage, it's not. It might seem like a long time, but we're talking over 17 years. And frankly, we're really looking at over 20 years. I mean, the law states 17, but I mean, these are folks that have been married, and most often it's been 20, 30 years, like in my experience. It really, because if we think of, right, how much the world has changed in 20, 30 years as far as dynamics of couples and spouses and who's working, who's not, those are the cases that we would see, where typically, and this is typically, the wife stayed home and the husband was the earner. And then, now 30 years later, they're getting a divorce. We're looking at a permanent alimony situation because of the length of marriage and the disparity in income. You can have 30-year marriage, both parties working, kind of making close to the same amount, right? It's not going to be quite the alimony case. So it really does, I don't know. I mean, I'd say, yeah, there's just a certain public or family that falls into that particular definition of alimony. It's not everybody.
I do think as times have changed, I think probably the number of permanent alimony cases is going down, because we're seeing more women in the workforce, less women are stay-at-home mothers. Whether that's a change that as younger folks, come up and start getting divorced, we see some differences, who knows? But currently I think at least women of my generation, and probably yours too, Heather, more and more of us are in the workforce. So permanent alimony was getting to be less of a thing because we were earning significant income. And oddly enough, we've started seeing more women paying alimony over time too. I say those things to you because I think it's part of the reason why when we look at the alimony statute, sometimes revisions do need to be made because things are changing. That being said, there's certainly still a lot of stay-at-home moms out there. That is a hard job, right? And those
Indeed.
women still, qualify currently for permanent alimony if that's the scenario that they're in.
Right. But, and often, because we'll go through, I mean, without delving so much, but it's going to talk about the length of marriage. And of course, the need. It's the financial need, right? We've got the one earner, and if they've got the ability to pay, and then there's the need. But what, many times, in my experience, I will have that conversation with women. Maybe they were married very young. And so they're like, well, I've been married 20 years, and that's fair. I get it. But you're 40, which, gets younger and younger, because from my perspective, every year, right? And so, but you're 40, maybe you do have an education, maybe you don't. And so permanent is probably not where we're going to end up. Now, it may be, significant for a period of time, but, as you know, Beth, like, everybody's factual situation is a bit different. And it really does, all of those facts are so very important in alimony.
Well, we say this a lot. Families are different, and that includes when you look at alimony, and includes when you look at time sharing and things like that. Families can vary, and they do vary from one another.
They do, and often as well, now I think we see differently. Shoot, even though from when I grew up, it's different, and certainly my circumstances are different. Like, it's a partnership from mother and father. Like, we work together, because you can't work unless your spouse is also pitching in. I mean, he works as well, but that's why I think we do see the evolution in the time sharing, because more fathers are actively involved in childcare and child rearing. And that is something I see all the time, just even, with friends, families, but very, very different from my grandparents' situation. Guaranteed.
You do see a lot of that. And what's interesting about the state of Florida is sometimes there's a lot of differences in families just from where they live. Like the
Yeah.
dynamics in Clay County look very different than the dynamics in Miami, right? And
Very
so
much
you
so.
do have this differences in families. It's not only impacted by generational things, but also by location, where you may be in a rural area versus, a major metropolitan. And those families, their needs, their expenses on alimony look very different than what it's going to look like from one place to the other. Their incomes could look very different too, just by
Absolutely.
location.
Yeah, right.
Right.
By location within our state, there's no doubt about it, because you're right. It's far different expenses and needs and overall lifestyle and all of those things. Just for our listeners, guys, that matters. And that's why we're talking about it. And it's so important. It's difficult for many clients, for many folks, once you enter into this realm of divorce and the courts, because you're like, well, my sister got this, my best friend got this, that should be me. And it just doesn't work that way, because every family truly
It's
is different. And it's so important that we know that all the facts, they all come into play for so much of this, that many individuals don't know, especially our listeners, right? Because you think, well, it should be this or that. And, there was really, and I always try to remember the pop culture, but there's that show recently on one of the streaming services. It's really, but anyway, it's where the woman, just they're gazillionaires because of the tech industry, and she gets all this money as part of the divorce. Again, a different area, plus it's TV. As we talk on the show all the time, that helps, that really distorts our reality as far as what we are going to experience in the Florida court system. But so many of these things, come into play when we're talking about alimony, and how it's going to work in your particular case, because your facts matter.
I do think the new bill will give a little more certainty on some things when attorneys and families look at it. I mean, there is still some discretion for judges, but there's a little bit of a formula in the new bill for how we're going to calculate the amount, but it is the lesser of need versus that formula. So there's still this discretion in the bill that will, I think, account for families' differences, which is a good thing. So,
well, that's exciting. That is a great teaser, Beth. So thank you, because we are going to take a quick break. And then come back and talk about the new law. Like, what does it mean for our listeners here today? But as we're on break, listeners, please take a moment to review and subscribe to our podcast. We are streaming on most major podcast platforms like Spotify, Apple, Google Podcasts, and iHeartRadio. We will be right back. Welcome back, listeners. And again, today I am joined by Beth Luna, an attorney in Florida who was intricately involved in the new bill before our Florida legislature on alimony. And that's what we're discussing today, alimony and how it will potentially be changing here in Florida. All right, Beth, so now we got to give our listeners, we teased them the last segment, we gave them some information on alimony as it stands and how those things are, what things really affect it often. But now we got to talk about the alimony reform bill that, as we are here today recording this show, it's on the governor's desk. So we don't know if it's going to become law or not. However, we're going to now know what's in it if it does.
And to be honest with you, I don't know if it's I hate to say that I don't know. I don't know if it's made it to the governor's desk or not, but it's headed that way.
It's headed that way. You're right.
It's
I looked at it last week and it wasn't there yet, I think, based on, and that's what we can figure out on the websites, right? With the Senate. But we believe it's headed there.
I believe it's headed there. It has passed both the House and Senate, and it's been enrolled, so it should be headed there.
Okay, there we go.
Then it's a question of what he does with it. Well, So you want to talk about the things that this bill does. Well, as a general big scope overview, it does change some things. The big thing is it takes out the word permanent. So there's no more permanent alimony. There is durational. That still remains. Bridge the gap still remains. There's a lot of things that still remain in the bill, but permanent doesn't. It does make some changes to the length of marriage, what we consider to be a long-term versus short-term marriage. Those, like, for example, in the past, long-term was 17 years. It's now going to be 20. So there are some differences there. There is some guidance to judges and magistrates around the state and attorneys and families as to what the number might look like and how long it's going to be. So there's some information as to the type of alimony, how long it can maximize be, and how much it can maximize be. So the maximum amount that it could be versus the length. You still have to find need and ability to pay. That's still very much a part of this bill. And you still have to go in on these cases and prove those things. Because if you don't have the need and you don't have the ability to pay, you're not going to be an alimony recipient or paying alimony, right? It also does some things in terms of retirement. For example, the PIM case has been around a really long time. And when you look at the PIM case, it talks about when a payor of alimony can retire and what that should look like. That has actually been codified into this bill. So that's in 6114, and those changes are in it. As well, the supportive relationships, that has always been in the bills, been in the statute, but now it's got some things like for supportive relationship, we can look back 365 days, that's specific in it, to see if that relationship existed. Those factors have been cleaned up a little bit and a little more streamlined. I think they'll still look familiar to people, but they have been a little more streamlined.
Why the
So
look
that is
back
all in this
date?
bill.
Was there something very specific about that with the 365 days? That is why it's in there. I'm sure there is.
Yeah, there is. Well, and I don't know from everybody's standpoint, but I know as part of the reasoning was there were some complaints that you would see people receiving alimony would have these supportive relationships, and they would end up finding out that the other person was going to file for modification based on that. They would suddenly break up very quickly,
Right.
even though it wasn't a real breakup. And then as soon as the case is over, they're right back living together. So the 365-day look back was really intended to allow the court to look back to see if that relationship really was a supportive relationship, if it really was something that was ongoing, or if they just suddenly moved out. It was to kind of give a little bit of look at that. So that's part of the reason that's in there.
Well, and that makes sense. Now let's talk a little bit about the permanent alimony. We talked in the first segment, and so if you missed the beginning, please go back, because we really did talk about, what permanent alimony is prior to this bill, and that it also maybe isn't truly permanent, but that was the word that has been used. So that word is going to be eliminated. Is there a type of alimony, like a word that's going to take its place, or is it just going to now be termed alimony or durational?
It's just going to be durational. And so looking at the bill, I will tell you there are some exceptions that would let the court exceed the time period that's put in here. So specifically, durational alimony is not to exceed under the bill 50% of a short-term marriage, 60% of a moderate length marriage, or 75% of a long-term marriage. And those numbers are not random. I know that in years past, it wasn't me in particular, some attorneys kind of ran through those numbers to see what it looked like. And they were finding that most permanent alimony awards were really about this, right?
Okay.
It's not to say it's a perfect fit, but we do think it's likely to be sufficient for most marriages. But then there are some exceptions that if there are clear and convincing evidence of those things, that the court can maybe override those percentages that would allow for a longer period.
And what are some of those? Because I know our listeners are gonna want to hear that.
Sure. And I'm going to kind of almost read them to you so you get them clearly. The extent to which the person receiving alimony, age and employability would limit their ability for self-support, either in whole or part. And I think that's a really good factor for a lot of reasons. It's going to let us really look at those cases a little differently. The extent to which their available financial resources limit their ability for self-support in whole or in part. The extent to which they may have been diagnosed with a mental or physical disability that has rendered them incapable of self-support. And then there is the factor that will allow us to look at if they're a caregiver to a mentally or physically disabled child. And that's, the child who's going to age out at majority and maybe not be able to care for themselves. So that is another reason the court can override those time periods within the statute. So I do think those are some good, solid catch-alls, and they do still give the court some discretion if they think the 75% on, say, a long-term marriage is not enough, right?
Right. And I think that is very important because if memory serves me right, in years past, because there's been a lot of years and a lot of, criticisms as to why when this bill, a similar type bill, never passed, or alimony reform, I think is the catch-all, what people would say. But a lot of it is you can't take the court's discretion away, because that, that's important. That's why we have our judges and our magistrates, so that, in an event where we need some discretion, or there is a case that maybe we think, hey, this doesn't fit in a box. Therefore, we need to look at what's equitable and what really is the best decision that allows the courts some clear, categories where things may fit in there, and they can use their discretion to make what they think is the best decision, maybe not just a formula.
Yeah, that's true. It's good to have that discretion in there, but it's also nice to have the guidance, because I do think that may help with settlement in terms of people spending tons of attorney's fees. If you don't qualify, and you clearly know you don't qualify for one of these exceptions, well, then you can look at it with a little different eye as well too,
And I think so, and it does give some clearly guidance. And let's talk about, which I don't know if I have my calculator, but so we've got a 30-year marriage. So now we would know, if there's a 30-year marriage, the maximum amount of time of the alimony would be 75% of that. Is that correct?
That's correct.
So let's see. So that's 22 and a half years, I think, if math is done correctly. Yes. So, okay, that's not like, I think once you said that, like, that is what was definitely needed, that I don't recall however many years passed that was in there before, right? There was like half the year, I think the percentage based on the length of marriage is a good thing.
Well, and look at that 75%. So for example, you have somebody who was married at age 20, right? They have a 30-year marriage. That puts them at 50. And then according to my calculations, that they would be 72 by the time that durational alimony would stop. But that number, there's retirement on the other side of this. So you see a lot of alimony awards being impacted by the retirement of the other spouse. So it does really get them past that kind of retirement age, in terms of length, where they would automatically probably be reviewing it anyway for most people based upon their retirement.
Absolutely. So I think when we take those numbers, do the percentage, and then again, really look at their age, okay, probably prior to this law, there would be an evaluation at that point anyway. And, and a lot of factors would go into that. Again, looking at the need and the ability to pay, and how much retirement, now you're receiving. That would have been the other separate part of the divorce, with the equitable distribution and the Social Security. Now, where are you on that? And a lot of times that is really reasonable, fair, and equitable.
A lot of times it is, again, it's a case by case. And I think that's, again, why you have the exceptions in here. There are going to be some cases where you have somebody that can't self-support, and maybe we do need to look at something different. Or you've got that child, right, who's a disabled child who's going to be disabled even through adulthood.
Exactly, which then is an economic strain, as well as the inability to then go out and earn.
Right.
Now, let's talk about this retroactive, which means, okay, for you listeners right now, you're like, oh my goodness, I am receiving permanent alimony. What is going to happen to me? Because I know my ex, as soon as he gets an opportunity, he's going to go back in and try to terminate that. So where are some of those protections? I know you talked about in the first segment on the retroactivity.
So it's interesting because there are a lot of different opinions on retroactivity. I can tell you from the standpoint of having worked on this bill, it was not our intention to create retroactivity. It was to make sure that prior awards prior to July 1st, which is when this bill would be effective if signed, would still remain under the old statute in some ways. Okay. If you look specifically at the bill 6108, it applies very specifically. Okay. It applies to pending or initial petitions for dissolution of marriage, as of July 1st. So it's either pending as of July 1st or you file it after. And it says specifically petitions for dissolution of marriage. I would argue to you the fact that that's in there should tell everybody that it was intended that this narrowly apply. That does not say that in 6114. 6114 is where we have the codification of the PIM case, its modification. So that retirement issue, the supportive relationship is in there. And those are all issues that were in the statute before. So they're not necessarily applying retroactively to those old awards. So, and there's some cases, without getting really in depth about the constitutionality of it, how we write statutes. We believe, we hope that the bill is not retroactive, and it certainly was not the intent. And I think if you look, the fact that within 6108, we say so clearly what it applies to, and we don't say that in 6114, should hopefully give the courts that guidance to follow that. I mean, it'll be interesting to see, because court interpretation, when you draft statutes, you do your very best to make them every comma in the right place, every period, everything perfectly. And sometimes the way they get interpreted by courts are different than what it was intended by the drafters, right? And you do see that. And I'm not saying that this is going to happen with this bill, but realistically, people are going to put that challenge out there. They're going to try to see if they can get it to apply. My hope is that it does what we intended it to do, which is not be retroactive to those awards that were prior to July 1st, 2023. So
yes, and that is going to be to be determined. Certainly not initially. However, as time goes on, and just like Beth said, for our listeners, the judge is going to read it, and also there will be facts, right, in certain cases, and it gets interpreted that it should apply or it should not. But currently, just for our listeners that understand what Beth was saying, our Florida statutes now do provide for anyone who's paying alimony to go in and modify, meaning change, based on changes in circumstances, which there's a whole legal definition and parameters to get in. But as it stands now, there are reasons to go in and try and change the alimony you're paying or the alimony you're receiving. And so those aren't going away.
Those are not going away. They've been codified, for one thing. The PIM case was there all along. It just wasn't really clearly in the statute, and it's now very clearly in the statute. Likewise, supportive relationships. I mean, it does have the 365 look back, but that has always been in the statute. So these things have always been around in concept, and we don't think it's retroactive. Again, how it plays out in the court system may surprise us. I hope it doesn't. We definitely, again, it was the intent that it would not have retroactivity in it. And I think by so clearly putting in 6108, which is the initial determination, that applies specifically. So specifically, that's what the courts, I'm hoping, lean into.
And that will be to be determined. So we will definitely put, a note in there and do another episode in a year or so and see what we're finding for sure. We'll invite Beth back and go, wow, we expected this, we didn't expect this.
There's a lot of opinions for sure on it.
Without a doubt. Yes.
The First Wives Club they think it's retroactive. We said that we don't believe that it is. It'll be interesting to see, because again, attorneys are very creative in their arguments. Let me say that. So you just never know, but it was not the intent for it to be. And we think that the language we put in is where you should look to very clearly within the statute.
And again, just for our listeners, because it applies all through Florida, and we have a lot of different judges all throughout our state, and creativity and the arguments, judges are going to hear things, apply things based on those circumstances. So that will be determined. However, knowing the intent and understanding that there is specifically a statute to address a change and modification in alimony, hopefully will carry the day for the majority of cases, even more than the majority. But again, we will wait and see on that one. And we are going to take another short break, and we will be right back, listeners. Please take a moment to check out our website, FloridaWomen'sLawGroup.com, and on social media for Women Law, on Instagram, Florida Women's Law Group on LinkedIn and Facebook. And we will be right back. Welcome back, listeners. And we are finishing up on our conversation with Beth Luna, talking about alimony, one of my favorite topics, even when we're talking about potential ways that it could change. But what we're talking about now is let's really dig into the reality, because obviously the show is women winning divorce, and I'm always looking at it from the women's perspective. But we're talking about alimony changes, and what will this mean for women in the divorce process? So let's talk about that, Beth. Now, when the court, are there going to be some changes that are significant as far as what the courts can consider now in looking at alimony that weren't there before?
I mean, I think, again, the big significant thing is the lack of permanent. I think that's the huge thing. I do think in alimony, you're still going to be looking at need and ability to pay. So you still got to find the need for the person that's asking for it, and you've still got to find the ability to pay. So that's still there. I think there is, oddly enough, this bill, a lot of sameness to it, but some big changes too. And those are the changes probably that we've hit on, which is the removal of permanent, the length of marriage changing, the length of the alimony, what that's going to look like, and then the amount is impacted some. I think those things are going to make some changes that are hopefully positive for both payors and payees. And I like to say it that way because I recognize not all women receive alimony, right? Not all women are candidates for alimony. Some women are candidates for potentially paying alimony now. So
yes, and that, let me just tell you from my perspective, Beth, I've been doing this a while, and as much as men don't want to pay alimony, women are even more it seems so wrong for many women I have over the years spoken to, but they have exposure because they have been the primary breadwinner in those types of cases. Yeah, so it's real for them as well, and it remains real because the law is talking about that, right? That right. Disparity in income, and
the bill is not written man versus woman. It's written, to address the need of a potential spouse who needs alimony versus a person who potentially can pay it. And so, that could be, either spouse in any relationship could end up having to pay it and end up receiving it. So I do think, that's one thing to keep in mind with this particular bill. And of course, the statute as it's written now is the same way, right?
Absolutely.
When we get past the alimony on this, there is a little nugget on time sharing in here that I think gets overlooked by a lot of people that's in this bill, that I actually think may have some positive impacts for families in Florida in particular.
Well,
but I'll hit on that when you're ready to talk about it.
No, I do. I want to know.
Well, so if you look at the bill towards the bottom, there's some language about if you're a parent moving, you live more than 50 miles from a child and you move back within 50, it would be a basis to modify the time sharing. More importantly, I think, so time sharing, once you get a final judgment, it kind of seals it a little bit in cement, right? Mm-hmm. And we don't change that unless there's a substantial change of unanticipated circumstances. This bill actually takes out the word unanticipated. And it's so interesting to hear people's perspectives on it. When we first started talking about doing it, I kind of played out all these scenarios in my head. And what the word unanticipated has done in the case law for time sharing over the years, it's done a lot of prevention of where parents improve themselves or their circumstances that the courts were then, their hands were tied to make any changes. Like, for example, the parent who's drug addicted, when they maybe get the final time sharing plan and as a part of the divorce, they're stuck with supervised visits, but then they get sober, they get their lives together and then want to come back and modify. And there's been some case law that has said, well, no, it was kind of anticipated that you were starting to get yourself on the right road, so we can't modify it. So by striking that word, I think we're opening up an opportunity that's hopefully going to be very positive for families, in that if a parent has made modifications that are positive, whether it's being sober, or maybe they went out and got a very small apartment and just said, I'm going to let mom or dad have majority because I don't have room for them. But now I've gotten on my feet, I've gotten stabilized, I can afford to have the children more. Maybe it's going to give those parents and those kids an opportunity to have more time with those parents because the word unanticipated is no longer there.
What was the, because and this happens, I know a lot, sometimes there's a bill, because this is like on alimony. So what was the thinking in putting something on about time sharing in an alimony bill?
So I know how the language on the 50 miles happened, and my understanding on that and the history that I know about that is that there was a representative who had a constituent, and this happens a lot, who came to them and said, "Hey, I was living like in another state when we got divorced, and the time sharing schedule was set based on that. And I picked up and moved back, and I now live so close I could walk the kids to school, whatever it was. But the statute won't let me change because it was anticipated that I might move, right? And so I've got this long distance time sharing schedule when I live so close to the children." And so we got approached about how to fix that. And so basically the sentence is very clear on that. There's a clear sentence on that. But in that discussion, we were like, what really fixes this, even without that language, is striking the word unanticipated. And so then within the family law section, we started having this very clear discussion about like, well, what does that look like? And what other impacts does it have, positive or negative? Is it a positive thing for Florida's families or is it not? And, ultimately, I kind of came down, this is me personally, I don't want to speak for everybody. I came down because not everybody agrees. I came down on the side that I thought it was probably a positive change because I don't think we should, punish parents if they improve, right? I do think it's about the best interest of the kids and we should look at what's best for them and follow the statute in that. But we were so restricted and hand tied, right? In terms of the parent who was particularly, like I said, had a drug or substance abuse or alcohol problem, and then they get themselves straight. Sometimes they were just stuck with supervised, even though the reality was they might be in a place where more time sharing would be appropriate. And not just because they were clean, it's a lot of other factors when you talk about the best interest of kids. But striking that word, I think, will allow the courts to maybe evaluate those cases without saying, well, it was anticipated you would get sober. It was anticipated that you were in the military and that you would at some point not be in the military and move back closer. I mean, that's another example of that. Or like I can look at police schedules and firemen schedules that are sometimes, you craft those schedules for time sharing very much around their schedules, right? Because they're kind of on or off a couple of days. You could say it was anticipated that they would eventually retire from those programs, but then you can't go back and look at the time sharing when maybe for everybody it was better. Or it was anticipated that the children would go from 2 to 17. And I think we all know what a time sharing schedule looks like for a 2-year-old can look very different from a 17-year-old. And so the courts were having to say, we can't grant this because it was anticipated they would age, or it was anticipated X, Y, or Z. Now I think it's going to give the courts an opportunity to look at it, to at least see whether or not it warrants a change based upon all the factors. So
that's an interesting tidbit. And, as far as that will allow for those types of cases, because you're right, especially on the aging of the children. And it's like, well, no, it's anticipated they were going to go to elementary school for preschool or to high school and things. It's hard to say that, obviously you think of it, but when making a parenting plan and creating these plans, the courts, the attorneys, everybody does the best that they can. But children do age and they do change and their needs change.
Yeah.
And so do individuals. And very often it's difficult to get that change codified in agreement unless there's agreement between the parties. And I know we typically see the ones that aren't. So that then, and they're looking for that avenue in the court system. Now, we talked a lot about supportive relationships in the first 2 segments, but I don't know that we defined it, Beth, for our listeners. And this has been around for a long time, but I think it's good to talk about it because, it used to be that once you got alimony, you got alimony. And so very often, women and or men, they would live together and not get married to in that alimony. So when we define a supportive relationship, because that's evolved over time, it become, the definition and different views as the courts have interpreted. So really for our listeners, how would you explain that for them so they understand what this means?
Well, I'm going to try to not talk about it in legalese, which is kind of a little bit difficult in some ways.
I know.
I don't think a supportive relationship is necessarily So for one thing, there's a definition and then there are factors to look at. And I think you have to look at everything. And I think that's, judges, magistrates, and attorneys, we should all be looking at everything because you may have a child living with you who's over the age of 18. And I think, or a family member. And so people get real concerned that that's going to automatically qualify. And when you look at the definition, a supportive relationship is someone who is not related by, and I can never say this word, consonant, never say it, or affinity.
Now I'm not going to be able to say it. So,
I feel like there should be a better word for what that is. But anyway, so you're kind of really looking for a relationship that is something more. I've heard the concern
like
about
romantic, right?
Like romantic. And I've heard people get worried about like roommates. Well, I think that's going to really, when you look at the factors, sometimes you determine alimony on the basis that they couldn't afford to live without living with somebody. And the new factors are pretty good, I think, at outlining like things that you need to look at, including like the ability to self-support. So, hopefully, I don't think the bill was intended or the statute currently was intended to prevent people from having a roommate, right, so to speak. It was more that you had this supportive relationship, which takes on a lot of different elements than just you're sharing expenses, right? Could a roommate result in you getting a modification downward because you've reduced your expenses? That's a possibility, right? But I don't think that in my mind, that's necessarily always a supportive relationship. You really have to look at the situation, who that roommate is. Are they sharing, bank accounts? What are they doing beyond just being roommates, right? So I think that that's something that's going to kind of play out kind of interestingly, but I don't personally think the supportive relationship change in the new bill is huge.
Okay.
I think we did a lot of cleanup. I mean, there's still in here the amount of time that they've resided with that person. If they've got joint bank or financial accounts is something that you still look at. You're going to look at whether or not they're financially supporting each other by paying the other person's debts, their expenses, or liabilities. In a traditional roommate sense, you're paying like one half the rent, one half the electric, that kind of thing. The extent to which they've given valuable services to a business entity of that person. I think the extent to which they have real property together. So that, again, these factors are really kind of designed both in the statute currently and in the bill to really weed out, is this really a supportive relationship or is it something different? Right.
And I think that's helpful. And because I've always looked at it as it's more than someone that is a platonic relationship, you're sharing expenses. It has to go another step further. Of course, that, again, is on your need and ability to pay. But when we're really looking at that supportive relationship, I think that, for our listeners, it's, and I just say that, but like, it's more than just, hey, I couldn't live on my own unless somebody was paying half the bills. There's more to it, I think, and certainly within the intent of the law, that now you're in a relationship that similar to what is defined as marriage and similar in many ways of you guys sharing. And I think that's a big part, that sharing the financials and helping one another out in more than a friendship, and it tends to be an ongoing thing. It's not just like a one-time type situation, right?
There is a good new piece when we come back in the bill on supportive relationships that I'll point out to you guys. I'll give you a little bit of a segue into that. So,
well, and I think, it helps because at the very least, I know for our listeners in this show, we've talked about a lot, and there's going to be a lot more, and you're going to need to certainly consult your attorney and get information because your facts, and we didn't cover everything, how this bill, even when it passes, which keep your eyes out for all of our social media that we've directed you to, because when it does, we'll let you know. But you're going to need that specific advice on your facts and how this applies to you, right?
It is very fact specific. And again, different families, different scenarios are going to look different. There is now within it, this bill there is something that requires the court to look at a supportive relationship as to whether or not the alimony is being paid as well too. So if you have somebody whose spouse is not paying the alimony and they've been forced to go live with somebody, the court can look at that as well too. I think that is a great addition and a needed addition for Florida's family.
I think so. I think that, allows a lot more latitude by the courts, and also to say, hey, did you force this person into this situation as well? Well, we have reached the end of the show, but one more thing. Now, if this gets signed, Beth, and becomes a law, it takes effect when?
July 1st, 2023.
All right. So
and
that's
again,
when
don't forget, 6108, it's only to pending and initial petitions of dissolution of marriage. 6114 is everything. So
that's right. So I think we'll be saying that a lot. So that, because it's not, the laws evolve. We'll see if this one evolves and gets updated, and then it doesn't apply to everybody, but you need to, if it may. And so that's why you have to seek out legal advice and understand how this affects you if it does. Well, we've reached the end of the show. Thank you so much to my guest this week, Beth Luna. It's been just a pleasure. And I know I find this so fascinating. I could talk to you on this bill probably for days on end just to get the different nuances and understanding. So I really am thankful to you for joining us today and giving us your insight into the new law.
I appreciate you having me, and it's been a real privilege to be co-chair of legislation with the Family Law Section. I really enjoy that work, and I'm always proud to be part of an organization that I think really puts its foot forward in trying to do what's best for Florida's families, and putting their best interests wholeheartedly to the forefront.
Well, I appreciate it, and I'm thankful too, because Lord knows we don't want to leave it just up to the legislators, right? You got to have people who are in it, doing it, have impact on these things. Otherwise, it makes it much more difficult on the Florida families, as you've indicated. But lastly, I have one more question for you. If you can impart on our listeners what you've learned about divorce and, representing or teaching women, residing over women throughout your career that you can impart for many of our women listeners.
I think, and this is going to be personal in nature, one of the biggest things I've learned with other women is that we are really at our best when we are supporting each other and pulling each other up. That we don't have to step on each other to get places in our careers and in our lives, that really we are the most powerful when we are helping one another and pulling each other along in our successes and in our moves up in this world. And so that's something I feel very fortunate to learn from an amazing group of women out in Nevada when I practiced out there, and it's carried over in a lot of aspects of my life. And I think that's true. I think when we support each other in our personal lives, in our careers, and we're good to one another, we really are a tremendously powerful source in this world as women. So that's why.
Thank you. Thank you so much. I very much appreciate it. And if you or someone you know is going through a divorce or thinking about a divorce, of course, reach out to us at FloridaWomen'sLawGroup.com or join our Facebook group, Women Winning Divorce. The link will be below in the episode show notes. And also, please leave us a 5-star review if you felt like this was helpful to you. We thank you for listening.
Thank you for joining me for this episode of Women Winning Divorce. My goal is to elevate your life and the way you are thinking so that you are best equipped to win at life. If you enjoy the show, please subscribe so you automatically get my new shows every week. And I would love to hear from you personally. Come join the conversation on social and join our Facebook group, Women Winning Divorce. We welcome your comments and suggestions. We want to bring you content that helps move your life forward. Women Winning Divorce is the place for an elevated conversation on how women can thrive during times of adversity in order to live their best life.